Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-7059. Media Matters for America and Eric Hanunoki versus Warren Kenneth Paxton Jr. in his official capacity as Attorney General of the State of Texas, Appellant. Ms. Pettit for the Appellant, Ms. Branch for the Appellees.
Ms. Pettit, good morning.
Thank you, Judge Henderson, and may it please the court. The First Amendment conveys neither a license to commit fraud nor the inalienable right to shop for the most favorable forum in which to litigate whether one has committed fraud. The easiest way for this court to correct the district court's erroneous conclusion to the contrary is to join its sister circuits in holding that a pre-enforcement challenge to a non-self-enforcing administrative subpoena is not cognizable in federal court. In the alternative, it should hold that this federal court is not the appropriate location to adjudicate the validity of an effort by the Attorney General of Texas to investigate potential violations of Texas law in Texas, an effort which is in any event entirely valid.
Ms. Pettit, what in your view is the actual possible violation of Texas law here?
The actual possible violation, and I would point this court to 17.46B8, is commercial disparagement of the good or service of another. In this instance, there is reason to think that Media Matters made factual representations about what is now X, what had previously Twitter's brand protection technology that were factually inaccurate and possibly harmed advertisers and consumers in Texas.
So is it your position that Attorney General Paxton can issue a CID, which is fairly intrusive, it asks for a lot of information, to any news outlet in the United States that publishes a story that he believes contains something that might be misleading?
No, not at all, Your Honor. In this particular instance, and I would point this court to page 472 of the joint appendix where Mr. I believe it's pronounced Carsoni, the CEO of Media Matters, was responding to the CID and discussed how this is a factual representation about their brand, about X's brand protection technology. As they put it, no matter how you slice it, they are misrepresenting what they're doing. Does
that answer my question? So whatever the nature of the misrepresentation, does Attorney General Paxton believe that he can issue a CID to any news outlet in the country because somebody in Texas might read the article, if that article contains something that he thinks is misleading about a business?
That is not sufficient under Texas law to constitute commercial disparagement. He does have the ability to issue a CID if he thinks that there is reason to believe that the news outlet has violated the Texas Deceptive Trade Practices Act. But it's not just that they think that it's unfair or misleading. There has to be a connection to a good or service in Texas. And here advertisers are X's primary customer, and misrepresentations about that brand technology is a violation, potentially a violation of the DTPA.
So anything that he thinks is misleading that could affect advertising income, he could issue a CID to any news outlet in the entire country?
Yes, Your Honor, if it has the sufficient nexus to Texas. But that's one of the things, and it's important to point this out, that the CID—
What's the nexus to Texas?
In this particular instance, and this goes, and the federal court in the X lawsuit found a similar, that it affects advertisers in Texas. And that is what one of the issues that the CID is actually attempting to investigate, is whether there is an adequate nexus to Texas. And if upon investigation we conclude there's not, we're not going to bring an enforcement action. But this court has recognized, and I would point this court to Reporters Committee for the Freedom of the Press on page 1051, that investigations of that type are necessary to protect the liberties that we enjoy, because there has to be some room for that. Otherwise, the news outlet would be claiming an exemption to generally applicable law, which the Supreme Court has repeatedly recognized they do not have.
So, Ms. Pettit, the Attorney General Paxton, filed an amicus brief in the Northern District of Texas in the case of ExxonMobil Corporation versus Maura Tracy Healy. And that was about a CID issued by the Attorney General of Massachusetts. And I was just looking at the table of contents of this brief, and it says attorneys general should act impartially. Attorneys general should not employ legal power to tip the scales in a policy debate. Attorneys general shouldn't target critics. Attorneys general shouldn't abuse of subpoena power. And politicized investigations undermine public confidence. I'm just wondering if you think any of these principles could be viewed as applying in this case.
Your Honor, I would point to the specific content beyond the table of contents of that brief. And I point the court in particular to the discussion in that brief about how the CID in question wasn't just aimed at disseminating accurate information. It was aimed at changing conduct outside of the courtroom. That is different from what is happening here. We are simply investigating whether there has been a misrepresentation. Media Matters is perfectly able and perfect, and we have no problem with them saying anything they want as long and doing anything they want in the public policy space, as long as they are not making material misrepresentations of fact that would affect Texas consumers.
Yeah. It also says here under targeting critics at JA 75, the First Amendment stands as a bulwark against government action designed to suppress ideas or information or to manipulate the public debate through coercion rather than persuasion. You don't think that applies in this case?
No, Your Honor, I do not. I think that in this case, the Attorney General has issued, and this goes to the question about whether this is litigating the merits is even appropriate, has issued simply an investigative request asking for information about whether these factual statements are true. If they are not the basis of an enforcement action. And I would point this court in that this goes to an important thing that gets conflated in a lot of the briefing here. The difference between the injury that Media Matters has asserted and the mechanism by which they have asserted it has occurred. Specifically, a chill to their reporting activities is the injury that is caused by the mere issuance of this CID. And the reason I separate those out is on page 11 of the Laird against Tatum decision, the court noted that the mere existence of a chill is insufficient without a regulatory, prescriptive, or compulsory government act. That statement was made 10 years after, I think actually
the issuance of the CID?
No, the act is not that, because as Reisman held 8 years, I'm sorry, I said 10, 8 years before the Laird decision, that a non-self-enforcing administrative subpoena like this CID is not compulsory.
Reisman didn't involve an alleged chill of First Amendment activity.
No, but Laird did, and Laird was after Reisman, and well, actually, I would like to tweak that just a bit. It did not involve an alleged chill under the First Amendment. It did involve an alleged chill of communication under the Sixth Amendment because it involved communications with a lawyer. And as this court's sister circuits have held in the intervening decades, that previous ruling about the compulsory nature of a CID applies in First Amendment cases. In particular, I'd point this court to Google
So why aren't those cases distinguishable? Because in this case, the assertion is the CID was issued, that's the government act, and it has chilled First Amendment activity of Media Matters. And there are affidavits that attest to how they have had to alter their practices because of the CID.
Because the chill by itself is not sufficient unless there is compulsion. And as Reisman recognized, as Balfour recognized, as Anheuser-Busch recognized, there's no compulsion with a non-self-enforcing CID. And as this court, and I'd also point that might also allay some of this concern in Rayburg against Polk, which is a case that's on the merits, it's not on ripeness.
It seems to me that the allegations in this case are a little bit different from the sources that you're citing, because what they're saying is, even though there hasn't been an action to enforce the CID, the fact that it's there and it could be enforced is affecting their ability to do their work the way they used to do it. And that just seems different from what you're citing.
Except in Laird, it was the same situation where it was the existence of a government investigation and the court found that was insufficient to create a cognizable injury. I'd also point this court to page 51 of the Younger opinion, which says that the mere existence of a chill, or page 46, the anxiety associated with an investigation is not itself enough to enjoin a otherwise lawful state action.
What are you resting? Ripeness?
We are
Failure to state a cause of action under the First Amendment, standing? I'm not, what?
all of the above, Your Honor. There are numerous doctrinal problems with this case. Our primary argument is Reisman because that is the cleanest under this court's sister circuit case law. But there's also personal
Including the
jurisdiction.
Fifth Circuit and Grewal?
including that Grewal was a personal jurisdiction case, not a ripeness case.
But it subsumed these same questions.
I don't
If it wasn't
believe,
ripe, the court should have knocked it out. Fifth Circuit didn't.
in that particular case, it wasn't a request for information, it was a cease and desist letter, which is important because the request for information is what this court said every citizen is subject to in Reporters Commission against AT&T. Here we have not concluded that there has been any violation of law, and we may yet conclude there has not been. We have simply asked for information because a news outlet is not exempt by itself from the DTPA. That is consistent with the Supreme Court's decisions in Brandsburg, in Bartnicki. The news outlets are required to follow the law just like everybody else. In terms of
Isn't that a fishing expedition, what you've just described? That you don't know whether there's even a connection to Texas, but you want to issue the CID to figure out if there is?
No, Your Honor. We think that there is a good faith basis to think there is a connection to Texas, and we have issued a CID in what first three requests are all about, is there a connection to Texas? If Media Matters provides information to suggest that there's not, then we wouldn't bring an enforcement action. But the enforcement action, and this goes to Judge Edwards' question about whether or not the Grewal case was right by itself. In the Fifth Circuit and other contexts that are related, they have said that a threat to bring an enforcement action is where you have the cognizable injury, which is compulsion or constraint. That's consistent with the Laird decision that we were discussing earlier. What we don't have here is compulsion. They are not going to be penalized for not complying with this CID unless and until there's a court order requiring them to do so. And they can raise all of these concerns in a state court proceeding, assuming one is ever brought. And that's what makes this case not right. It is entirely possible that an enforcement action will never be brought because it will be determined that this is not a
Well, the
useful
problem
use.
for you is if there are chilling effects and if that's a cognizable cause of action, your ripeness thing falls apart. It's present. It's available. It's something that they can litigate now if there are chilling effects.
Your Honor, that would be a departure from every one of the cases that the sister circuits of this court have
No, not at
ruled
all.
on.
Twitter, for example, which looks facially good for you, is distinguishable because the court there said there were no chilling effects. There are chilling effects here. There's something to proceed. The court in that case was saying the case would have gone forward had there been standing to pursue chilling effects. There were no chilling effects. Now here the question is, they're claiming there are chilling effects, and it looks like the complaint is different here than it was in Twitter.
Your Honor, it's no different. In fact, I litigated Twitter, and I would point this court to page 475 of the Twitter opinion, where the court talks about the affidavits and the allegations in that case. And my friend on the other side has suggested there were no affidavits in Twitter. That's simply factually wrong. And it said, for example, page 475, it is already that Twitter has put in forth, it is already being forced to weigh the consequences of a burdensome investigation every time it contemplates taking action. That's remarkably similar to Mr. DeMiero's statement on page 172 of the joint appendix, saying that stories that would normally be published from our usual vetting process, including stories about Media Matter coverage, are, and I quote, receiving greater internal scrutiny and risk calculation. It's the same allegations. And it's the same allegations that could be made for any investigation of a fraudulent claim. So if this court, or a claim of fraud, if this court were to hold in Media Matters' favor, it would depart from Twitter, from Rayburg against Polk, from all of the cases that are cited in our briefs.
Twitter. Depends upon how you look at the First Amendment claims. And Reisman doesn't help you at all because they didn't decide on ripeness. I'm not sure what Reisman says. I don't think any of you are either, but
Reisman says there was no compulsion and therefore no cognizable injury. And your sister circuits have either dealt with that under the concept of ripeness, which we think is the better way to look at it, because what Reisman was talking about is whether or not there were contingencies that have not yet come to force. And in modern jurisprudence, that is a ripeness question. But a number of cases, including the Rayburg ones that I've mentioned a number of times, have found it in whether or not there's a cause of action. Either way, Media Matters loses. But even if you disagree with me on all of that, there's still a personal jurisdiction problem here about trying to enforce this, or trying to litigate against the Texas Attorney General. Because as Burger King noted on page 475, the foreseeability of an injury in this jurisdiction is insufficient to establish personal jurisdiction as a matter of due process.
I'll ask you something about the Texas Business Code. This hasn't really been addressed in the briefs or by the district court, but I looked at it in section 17.61G.
Okay.
It says that the recipient of a demand can file a petition to set aside the demand in the district court in the county where the parties reside.
Yes, Your Honor. And if the parties do not reside in Texas, they can do it in Travis County.
But why isn't this the county where Media Matters resides? So
Because-
why can't, under this, the plain meaning of this provision, why can't they bring this case in district court in DC?
Because in read in larger context, that is a county within the state of Texas, and the District of
Where
Columbia.
does it say that? It doesn't say that anywhere.
It says that and I'd be happy to send you a letter to give you the precise citation, but that particular question has been litigated in another case and it was read to be in larger context of the county because the DTPA only discusses Texas and Texas.
Is that because it anticipates that it will be enforced in Texas?
It anticipates that will be enforced only as to conduct within Texas. It does specifically provide, and I would point this court to 17.61D3, that there can be service outside of Texas by mail. And under those circumstances, it still has to be a violation within Texas, but it does not have to be a violation that for people that are located in Texas, precisely because we have a national and an international economy, and things that happen outside Texas can affect a state within the state. And that is why.
No, I understand. It just seems that this provision seems to contemplate if the Attorney General chooses to try to enforce the Texas law, you can challenge it in the county where the parties reside, which seems fair.
In the larger context of the statute, and I'll see if I have it at the table. If I will, I'll give it to you during rebuttal. But the venue provision in the larger context of the DTPA provides specifically for venue in Travis County if you don't reside in a county in Texas. And so as a result, read in the larger context, the county in Texas is what that's referring to.
So you're saying if your principal argument is this is not ripe, your principal claim should be that the district court should dismiss without prejudice. And if and when the Texas Attorney General attempts to move and do anything with the CID, then the case will be resumed. That's your argument.
That is the question of whether it can be resumed at that particular point becomes a different question under Younger, because as Younger unequivocally stated, the longstanding policy of Congress, with very few exceptions, is that issues like this are litigated in state court. And so at that point, there may be a different issue, but the ripeness issue will likely have passed. We still would have the personal jurisdiction issue because the only connection.
No, I'm taking that off the table for this question. I understand your arguments about personal jurisdiction. I'm just focusing on your ripeness. If the district court should have dismissed for want of ripeness, then what you're saying, that's got to be without prejudice.
Yes, Your Honor.
Until what happens?
Until there is an effort to enforce, at which point there is a compulsion. Then the question there will still be other arguments that are related, some of which also relate to Ripeness, as this court, as Your Honor noted, that has dealt with a number of different issues, including whether there is a cause of action for a retaliatory investigation, which we respectfully submit that there is not. But the ripeness argument at that point will have been dealt with. But we agree that this should have been dismissed without prejudice so that Media Matters can raise all of these issues in state court in response to.
This is a Section 1983 claim. I know it's not, the cause of action doesn't seem to match what you're talking about at the podium, because clearly federal courts have jurisdiction to look at Section 1983 claims, and that's what this is.
Yes, Your Honor, but the basis, and this goes back to the Rayburg and Archer against Chisholm and a number of other cases that we cite in our brief, that a retaliatory investigation that has not ripened into, and this goes to why the two issues are related, has not ripened into an actual enforcement action is not cognizable under 1983.
That's not the cause of action that the plaintiffs are bringing. Like, they don't have to comport their complaint to what you think it should be. Their complaint is that their First Amendment rights are being violated by this investigation, which is retaliatory and chills their First Amendment speech, which seems to be quintessentially something that a federal court can look at.
No, Your Honor, not under Archer against Chisholm, not under Laird against Tatum, and not under Rayburg. This court would be departing from all of those authorities to find an investigation by itself is the source of a 1983 claim. All of these claims are being litigated under Section 1983. The question is whether that is a theory that is cognizable for retaliation, because retaliation involves a number of elements, and the courts that are examining that retaliation have said that the investigation by itself is not an act that will, and I believe the phraseology is
I don't
chill.
think that you argued that First Amendment retaliatory investigations are not cognizable. That's something you forfeited.
That is something that they have asserted that we have forfeited, and in response, we have cited back to this court its standard for what is preservation, which is that we have raised the issue that this is not a claim on the merits. And one reason that it is not a claim on the merits, or a valid claim on the merits, is that it is not a cognizable theory under Section 1983. Going back to—
You didn't raise the retaliatory investigation below.
We
You
raised—
didn't object to that.
We did, Your Honor. We raised
Where?
in
You didn't
our—
give a citation, I'll go look at it. I didn't find it the first time.
We raised that they had not shown a likelihood of success on the
Did you
merits.
say there is no such cause of action with respect to retaliatory investigation? I don't remember that.
I don't
That's a
believe
pretty
we did.
easy argument to make if that's what you intended to say.
We did not phrase it in that exact way. We phrased that they have not, I believe that we phrased it in the way that they had not raised and I believe the phraseology, I don't remember the exact quote from our brief, was that they have not raised a basis that would chill an ordinary speaker, and that this is an elaboration or a clarification on what we were saying, because it goes to the same element of whether or
Really,
not
it's
they
not,
claim.
we expect more.
Certainly,
In
Your
order
Honor.
to avoid forfeiture.
I respectfully disagree, Your Honor, but I take your point. And the question then, even if that's wrong, have they shown, and this we did raise, is whether they've shown an actual chill? And under National Treasury Employees Union, they have to on page 1255, and they haven't, in part because this would not be something that would cause a reasonable person in their circumstance to have changed their behavior, precisely because it's not for the reasons that it would not be cognizable, but also because their own conduct, and I would point this court to pages about 420 of the joint appendix, shows they weren't in fact chilled. And so as a result, even if it
I
were—
just don't see how that preserves the argument that there's no such thing as a retaliatory First Amendment investigation.
It preserves the argument that they have not raised a reason that a person in a similar circumstance would have chilled their speech. That's a species of the same argument. But if the court disagrees, then it still has all of the other problems, including that they have not shown a chill or retaliatory animus for that matter. But we never even get to that because they haven't shown a cognizable harm. Going back to Laird against Tatum, which is from 1972, the Supreme Court said that a chill— What?
You don't have to.
Great. Then even assuming the court disagrees on that, there's still the personal jurisdiction argument. I see that I'm way over time. You said that you understood our arguments. I'm happy to answer any questions on personal jurisdiction, but we strongly suggest that even if the court disagrees with me on the meaning of Reisman, that this is not the appropriate forum in which to be litigating this case.
We'll give you a couple minutes in reply. Ms. Branch?
Good morning. May it please the court, Aria Branch on behalf of the appellees. This is a unique case with very extreme facts. It involves the extraordinary overreach by a retaliatory attorney general who came to DC to harm a DC-based media organization by serving a sweeping demand for their internal and external documents because he didn't like their speech. And there's a reason why Attorney General Paxton had to come to DC to serve Media Matters. That's because Media Matters has no presence in Texas. It doesn't have an office there. It doesn't have a registered agent there. It doesn't engage in trade or commerce at all. And it certainly doesn't engage in trade or commerce in Texas. The district court's opinion in joining Paxton's demand was well-reasoned and largely based on facts that are not disputed. Paxton did not dispute in the district court that plaintiffs are chilled. Plaintiffs submitted numerous affidavits documenting that chill, how the demand is currently and presently affecting both the stories they chose to publish, their editorial process, and how they had in fact actually withheld articles on relating to X and Musk because of the chill of the demand that was hanging over their heads. It's also not disputed that Paxton served the CID because of journalism that was published by Media Matters. When Paxton commenced his investigation, he called Media Matters a radical left-wing and anti-free speech organization, and he encouraged other attorney generals to investigate Media Matters along with him. Paxton now argues that despite the fact that he came to DC and inflicted harm on a DC-based organization, he can't be subject to suit here because his investigation was launched in his official capacity. That argument is unsupported. It's not supported by Ex parte Young, which says that when a state official allegedly violates the federal constitution, he is stripped of his official and representative character and subject to suit in his person for the consequences of his individual conduct. His argument would also lead to absurd consequences for the jurisdiction of DC courts. Attorney General Paxton just argued that their primary argument in this case is that plaintiff's lawsuit is not ripe because Paxton has not yet taken steps to enforce. That argument is not supported by Reisman. Reisman, as the as the Ninth Circuit said in the Twitter v. Paxton case, is not a case about ripeness at all, and it's not a case about the First Amendment. Media Matters and Eric Kananoki, the plaintiffs in this lawsuit, have shown via affidavits that they submitted to the district court that they were currently and presently being injured. They could not wait for Paxton to decide to enforce the demand and have the CID hanging over every email they send, every editorial decision they make, every article they decide to publish, like the sword of Damocles. They are entitled, because they're suffering a present and First Amendment chill, to seek relief. And they sought relief in their home jurisdiction in federal court in DC because Paxton came to DC and served the demand via his agent, and he inflicted harm on Media Matters in DC.
Why are the claims here different from the claims in Twitter? Twitter is essentially saying, I mean, the threat, when you look at this case, there are a lot of cases like Laird, like Celine, which we issued here a year ago, where you can look at this and say, it's too soon. You know, there's nothing that has happened. There's a possibility of something happened. It's happening, but it hasn't happened yet. And so whether you go a Reisman way or whether you go Laird way or whether you go traditional ripeness, normally or often we would say it has to await a different moment. The way you're trying to get around it is to say, we have a viable claim. Forget all the rest of it, what might happen. We have a viable claim because we've been chilled. We've been injured. So we're in play and we want an injunction against any further injury.
That's
what
correct.
We've already suffered. What cases support that approach?
That's correct, Your Honor. And I think the difference.
What cases support that approach?
The Twitter v. Paxton case supports that approach. Although in Twitter.
But Twitter goes the other way.
Twitter goes the other way, but it makes very clear that a chill, and I quote from the opinion, a chill, a First Amendment chill, can itself be the harm. And it's very clear that had the court
Did they
found.
cite anything?
Does Twitter
In other words,
cite
is there any case? Twitter talks about the possibility only to knock it down. Is there any case that either Twitter or anybody else can point me to that says, yeah, that this is a viable notion, the potential chilling effects? I mean, that's the way you will survive. That's the only way, in my view, you can survive all of these other concerns about this is too soon. All of those doctrines, whichever ones we go to, they're a problem for you because nothing is happening. But what your way around that is to say something happened already, and we're showing the likelihood of a continuation of that happening, and therefore we would need relief now. All I'm asking is there anything other than Twitter's rejection of that to support that approach?
So I would point, Your Honor, to the Cooksey v. Futrell case from the Fourth Circuit and the Edgar v. Haynes case, also from the Fourth Circuit. Both of those cases recognize that a First Amendment chill is cognizable when the present and ongoing injury is being suffered. And I also would point, Your Honor, to Graywall, which is from the Fifth Circuit, Paxton's home circuit, where the New Jersey Attorney General sent a cease and desist letter to a Texas-based company. And the Fifth Circuit both asserted jurisdiction over Graywall and found that the First Amendment injury that was being suffered as a result of the cease and desist letter was actionable. And so the bottom line here is that we have asserted a claim, a First Amendment retaliation claim. We have met the elements of that claim. And the merits question here is whether the district court actually abused its discretion in finding that we satisfy the elements of the First Amendment retaliation claim. We've shown that we are engaged in First Amendment protected conduct. Media Matters is a news organization, which is the hallmark of First Amendment protected speech. We have shown that Paxton issued the demand in response to an article that Media Matters published, and that he did so without any basis, without any investigation. He issued the demand a day after X sued Media Matters in the Northern District of Texas. And he did so solely, he's admitted that he brought that lawsuit solely based on the allegations made in that lawsuit. And finally, we've shown—
What's the threat of the demand? There it is. I mean, that's the way they're trying to approach it. And it seems to me you have to answer that. There's nothing to it. There it is. And nothing can happen to you unless something happens, and they haven't made it happen.
The threat of the demand is that it is an ongoing demand for all of Media Matters documents related to
Can't you
journalism.
simply under whatever law is in place say we're not responding?
We could, and then there would be extreme consequences for that. Under Texas law, Media Matters could be held in contempt for failing to respond.
Is there anything to suggest that that's likely? Do you have any reasonable basis for assuming that that is a real threat? I understand the argument about there is a possibility, but what I'm trying to understand is, because otherwise it becomes self-serving. You say, well, we're threatened. We take this to mean bad things, and therefore we are threatened, and you have to believe us when we say we're threatened. Well, there are cases that say, as you know, in Celine, we dealt with that. Say that's not enough. Just because you feel threatened doesn't mean that the law recognizes you as such. What makes this, what moves the needle on this and puts it in a different category?
Well, I think the question on whether or not you feel threatened is it reasonable that an objective person would feel threatened based on the CID that's been issued? And the district court answered that question, yes. And I would point out, Your Honor, that Paxton did not challenge the chill allegations below. He waived that, and the district court found—
That is another issue, there's no doubt, and they don't have a good answer, at least not that I've heard yet on that one.
Correct, Your Honor. Today, they seem to be challenging the chill allegations that were made in the district court, but below they did not. And the question on the merits, again, is whether or not the district court abused its discretion in finding that we were likely to proceed on the merits. And based on the record that he had before him at the time, I think that answer is clearly yes. I also
think—
think—
Why is this case more compelling on the chilling effects than the court thought the Twitter case was? Because in Twitter, it's the same theory, but the court rejects it. And they said what was being asserted there was not enough. Why? What distinguishes the complaint here from the complaint that was being reviewed in Twitter?
Here, we have put forth affidavits that show from the COO of Media Matters, from the individual reporter who authored the November 16th article that is at issue here, and also from his editor, that Media Matters, the CID is hanging over Media Matters like the sword of Damocles, that every single email document they create could be subject to being turned over to the state of Texas to further an investigation against them. Media Matters is a journalism entity. It has to be able to do its work, and it can't do that with the CID hanging in the air. And I would point, Your Honor, to the comments that I think Judge Pan raised earlier that Paxton raised when he submitted the amicus brief in the ExxonMobil case, where he specifically said that a CID can have a chilling impact and that it can affect First Amendment rights. And when a CID is hanging in the air, it does have an impact on the targets of that CID. And so I think the district court found that the declarations and the affidavits that were sworn to and submitted in this case were specific, and that they were particularized, and that they put forward, evidence of chill that was uncontested in the district court. And he had before him a clear record of chill, and that's what makes this case different from Twitter v. Paxton, from Laird v. Tatum, from many of the other cases that Attorney General Paxton cites. In those cases, the plaintiffs simply did not present evidence of a present injury to First Amendment protected speech. I would just turn to the personal jurisdiction argument just briefly, unless your honors have questions on it. But we think it is very clear that Paxton is a person under the DC long-arm statute. To hold otherwise would create absurd consequences, as the district court found, for civil jurisdiction in DC. DC courts regularly exercise jurisdiction over federal officials who have their home offices in the district, and other state officials when they come to the district and cause harm. The long-arm statute is satisfied. Paxton both transacted business in the District of Columbia by sending a process server here, which commenced the investigation and resulted in harm to Media Matters and Eric Hananoki. And we also satisfy A3 of the long-arm statute because he committed an act in the district by serving the CID here, and that act gave rise to our injury, which is the chill of our First Amendment rights. In terms of due process, I think it is extraordinarily clear that Paxton committed himself to a course of dealing in the district by serving the CID here. The CID, on the face of the front page of it, contemplates that Paxton would come to the District of Columbia to inspect and make copies of any documents that Media Matters had that is responsive to the CID. And so the district court properly found that due process is satisfied because he both sent a process server here, he committed himself to engaging in a course of dealing, and it was absolutely foreseeable that he could be held into court here as a result of that, and also because he inflicted tortious injury on my client here in the District of Columbia. Unless your honors have further questions, I would ask that you affirm the district court's decision in joining Paxton's investigation. Thank you.
Thank you. Why don't you, 2 minutes? Why don't you take 2 minutes?
Starting with whether we are challenging the allegations of chill here, we are not, as a factual matter, because of the posture of this case. We are challenging whether it is legally sufficient. And I would point legally sufficient. I would point this court to United Presbyterian, page 1378. Then Judge Scalia noted that the chilling effect is cited in the cases upon which they rely as the reason why the government's action is invalid, not whether the plaintiffs have standing to challenge it. That is because the chill, and that principle goes all the way through most recently in Clapper. If absent some sort of compulsory act by the government, that chill is self-inflicted. Here, there is no compulsory act for a lot of the reasons that Judge Edwards was describing, because there are a lot of cases, and my friend on the other side called this extraordinary. It's not. It's a request for information from an entity accused of committing fraud. And their arguments, because the media entities have no greater ability to commit fraud than anybody else, would apply to any entity that is claiming that receives a fraud request. This court would be basically saying that it would be a chill to their speech in order to allow to investigate, and that is inconsistent with decades of precedent. Pointing then to the question of whether they are under some sort of Damocles, they are not. As the Twitter court noted on page 1176, enforcement is not a rubber stamp in Texas, and they can only be held in contempt if they fail to comply with the court order thereafter. Changing just to a moment for personal jurisdiction, because my friend has suggested that this would create absurd results relating to federal officers. That's inaccurate, and I would point this court to 28 USC 1391E, which creates nationwide service of process and nationwide venue for of federal officials acting in their official capacity, so that's simply irrelevant. And turning to their arguments on the on the long arm statute, they point to the fact that we hired a process server, but their own authority on page 1096, this Shea at page 1066 equates a courier like a process server with a piece of mail, and mail is insufficient. And because it is an act outside of the jurisdiction that may or may not have effects in the jurisdiction. That is effectively what they are asserting here, not transaction, not jurisdiction based on a transaction. And they have problems with that because the only way that they can establish that that the Attorney General has pervasive contacts with the District of Columbia is actually to cite the speaking engagements of his subordinates, including, for example, former Solicitor General Stone or Mr. Bosch. The problem with that is they can only tag the Attorney General with those if they admit that this is in fact a suit against the Office of the Attorney General, which they can't, because this court unequivocally said in Ferrara that a claim against a state agency is a claim against the state, which falls outside the personal jurisdiction of this court. There are no further questions.
Are you doubting the authorities that the other side is citing, supporting the notion that chilling effects is a viable notion? Indeed, as they say, Twitter itself says. And the difference here is that the district court judge here made findings, and it's owed some respect, and enough in those findings to support a claim of chilling effects. Are you doubting this? She cited at least 3 circuits.
The circuits that she cited, the only case that comes close to this one is Twitter. We admit that that is their best authority. We suggest that to the extent that Twitter found that an investigation by itself is sufficient to create that type of chill and therefore a cognizable injury, it's inconsistent with this court's ruling in Reporters Committee, as well as numerous Supreme Court cases. But even under Twitter, because the evidence that was relied upon is very, very similar to what happened here, even under Twitter, as Your Honor noted, this case should have been dismissed. There are no further questions. We respectfully request you reverse.
All right, thank you.
Case number 23-1291, American Whitewater petitioner versus Federal Energy Regulatory Commission. Ms. Nicholson for the petitioner, Ms. Gall for the respondent.
Ms. Nicholson, let's wait till the courtroom clears.
I'm sorry, what did you say?
I just want to wait till the courtroom clears. Right? Good morning.
Good morning, and may it please the court. My name is Haley Nicholson, and I represent the petitioner American Whitewater. In this case, every single resource agency and non-governmental stakeholder urged the removal of the 2 dams of the Somersworth Hydroelectric Project. And for good reason. There are many significant and permanent benefits to removing the dams, including providing 192 acres of habitat for at-risk species, increasing river connectivity, opening up boating opportunities on this stretch of the Salmon Falls River, and providing 9 miles of spawning and rearing habitat for migratory fish. In weighing these benefits and making decisions on how corporations may properly surrender their hydropower licenses, FERC undoubtedly has some level of discretion. But no amount of discretion stretches as far as to allow the agency to reject actual evidence of environmental and recreational benefit in favor of pure speculation.
Could you please just point to me the evidence in the record that supports that there would be actual recreational benefits? Because from what I've read, it seems the way you framed this, like there could be a restoration to a more natural state. And I'm trying to understand what the actual recreational benefits would be, because the FERC seemed to think that these were speculative recreational benefits. And I guess the record reflects that there's no public access to this area, this 0.3 mile stretch. and it's an industrial area. So I'd appreciate your guidance as to where in the record there's evidence of actual recreational benefit.
FERC's determination is contradicted by the record evidence. The only record evidence that FERC had before it about recreation opportunities were American Whitewater's comments, which this court can find in the joint appendix at AR 461 and also at 419. And in both of those comments, American Whitewater asserted that there would be boating opportunities if these dams were removed because there would no longer be any blockages to boating on this stretch of the river.
Could you point that? Because I looked at those exact pages and what I saw was, it was phrased as, quote, with the removal of the lower dam. I'm especially interested in the lower dam because I feel like that's not as well supported. This section of the river could be restored to a more natural state.
Yes, Your Honor. And it's American Whitewater's contention throughout its comments that their members would in fact recreate on this stretch of the river if the dams were
So
removed.
where's the evidence that they would?
The best evidence, Your Honor, is through the comments and also American Whitewater's declarations in both of them through Skipper Morris and the declaration of Ryan Waterhouse, which this court can find in the appendix to petitioner's opening brief. Both of those declarations assert that the American Whitewater members would in fact recreate on this stretch of the river if the dams were removed.
Is that enough? It seems to me that it's a rare thing for FERC to order the removal of a dam. They repeatedly say that's a rare thing. And just a few people saying that we would boat on the river if there were no dam, is that enough to trigger greater scrutiny? It just seems to me that there should be more evidence of recreational benefits than a few people saying we would boat there if we could.
Your Honor, the key point here is that there was record evidence before FERC that they did not sufficiently grapple with. And as the Supreme Court held in Motor Vehicle Manufacturers Association versus State Farm, where there's that contrary evidence in the record, FERC has to grapple with it and make a rational connection between the facts and the decision made.
So the evidence you're relying on is at JA 419 and JA 461 to 62. Is that all you're relying on?
There's another set of American Whitewater comments in Joint Appendix 247. So that works as well.
Okay, so those are the only areas of the record where there's evidence of recreational benefit, and that's what we should look to
Yes, Your
for
Honor.
recreational benefit. Okay.
In weighing these benefits and making decisions on how corporations may properly surrender their hydropower licenses, FERC must support its decision with substantial evidence. And while substantial evidence is a deferential standard of review, it still has limits. As the Ninth Circuit held in Woods versus United States, quote, substantial evidence cannot be based upon an inference drawn from facts which are uncertain or speculative and which raise only a conjecture or a possibility, end quote. Here, FERC does not have evidentiary support. It just has speculation. And their primary argument to reject the dam removal alternative highlights just how speculative and unsupported the agency's reasoning actually is. FERC claims that there are 4 detriments to removing the dams: impacts to the city's water supply, impacts to the city's infrastructure, aesthetic changes, and temporary water quality and noise effects from construction. But not a single one of these is actually supported by a scintilla of evidence. And you don't have to take my word for it. All you have to do is look at FERC's own conclusions and its surrender order, which this court can find in the joint appendix on page 440, where FERC concluded that out of all the evidence before it, the detriments to the city of Somersworth were, quote, unknown, end quote. In that same paragraph, FERC concluded that changes to aesthetics could be, quote, either beneficial or negative, end quote. Water quality and noise temporary effects, the last man standing, has no site-specific evidentiary support whatsoever. In other words, each of FERC's detriments have no record support, or they're drawn from inferences of admittedly unknown facts. Whatever the standard for substantial evidence, it requires more than drawing inferences from unknown facts. To make matters worse, not a single one of these detriments applies to back dam, which FERC did not independently address in its orders. At a minimum,
Can I ask you about back dam? Because it looks like Aclara's license doesn't include back dam as part of the project. So I'm just wondering why back dam is an issue in this case.
it's an issue in this case, Your Honor, because throughout the surrender process proceedings, FERC repeatedly states that it's part of the project boundary and part of the project itself. And so it's still at issue before this court.
So how does the project boundary differ from the project description? This just could be my lack of familiarity with FERC, but I don't understand that.
They're pretty synonymous, Your Honor. So the project boundary will include all of the project features, which in this case, FERC listed as including back dam.
Because the project description in the license doesn't include back dams. I'm just trying to understand how the project boundary upon surrendering the license, why does that differ from the project boundary for getting the license?
It doesn't necessarily differ, Your Honor. So while the license doesn't explicitly mention back dam, Acclarant did receive ownership over back dam and stone dam. And that project boundary includes all of Acclarant's ownership rights. And so here it is still at issue because FERC continues to claim that it's part of the project description and part of the project features.
So I guess I'm just wondering, like, how do we know that they own back dam? Because nobody uses back dam apparently, and it's not part of the project license.
That is correct, Your Honor, that it's not part of the project license and it's not used, but it's still part of the project features and project description that FERC considers.
Is there a source for why Acclar is responsible for back dam?
There is not a particular source that I could point you to, Your Honor, but I again would assert that this court should look at the language in FERC's surrender and rehearing orders, in both of which FERC acknowledged that back dam was part of the project. On the other side of the scale from FERC's missing analysis and purely speculative discussion of detriments is overwhelming record evidence of the benefits of dam removal. This court can find the evidence of those benefits in the joint appendix from comments of the U.S. Fish and Wildlife Service on page 403, from the National Marine Fisheries Service on page 261, from the New Hampshire Department of Environmental Services on page 343, from the New Hampshire Department of Fish and Game on page 423, from the Maine Department of Environmental Protection on page 427, the Maine Department of Inland Fisheries and Wildlife on page 415, and from non-governmental stakeholder Trout Unlimited on page 416. Therefore, FERC's rejection of the dam removal alternative was not supported by substantial evidence. And not only was FERC's rejection not supported by substantial evidence, but it was particularly problematic under the FPA and NEPA. Turning to the FPA, FERC's public interest determination was arbitrary and capricious because it had insufficient information to adequately weigh the factors it was considering. As the circuit held in Bangor Hydroelectric Co. versus FERC, and as the Second Circuit emphasized in Scenic Hudson Preservation Conference versus FPC, reliance on conclusory assertions does not satisfy the substantial evidence standard and is highly problematic under the FPA. As those courts discussed, FERC, when acting under the FPA in the public interest, has an affirmative duty to inquire into and consider all relevant facts. FERC did not do so here. FERC's conclusory determinations fare no better under NEPA, namely because FERC failed to take a hard look at the dam removal alternative. As this circuit held in American Rivers versus FERC, FERC's hard look, quote, will pass muster only if it undertook a well-considered and fully informed analysis of the relevant issues and opposing viewpoints, end quote. FERC did not do so here, as it had only admittedly unknown effects of the dam removal detriments. Therefore, FERC violated NEPA by failing to take a hard look at the dam removal alternative. For the foregoing reasons, American Whitewater respectfully requests that this court grant its petition to vacate FERC's surrender and rehearing orders and remand for further consideration of the dam removal alternative. Thank you.
Ms. Gale.
May it please the court. I'd like to start with Judge Pan's question about the evidence of recreational benefit in the record. And Judge Pan, you're correct that there really is no evidence of concrete recreational benefit. And that's the heart of the issue here. There were concrete uses of the dam as to the city's water supply, fire suppression, infrastructure, and other essential services. And the commission had to balance those concrete uses against what it viewed were speculative benefits on the other side to recreation and fish passage. So to be frank, we're considering recreation along a 0.3 mile stretch of industrial riverbank. And this isn't, for example, whitewater rafting in the Colorado River in the Grand Canyon. So when balancing those potential benefits against the concrete uses of the dam, the commission reasonably determined that dam removal was not in the public interest.
So it does seem to me, Ms. Gao, that the commission focused heavily on the Stone Dam, which did have all of these, I think, clear benefits in terms of water supply and fire suppression, et cetera, and gave a lot less attention to Back Dam. And basically just said, if we're not going to do Stone Dam, doesn't make sense to do Back Dam because it's only 0.3 miles. And then there were some general things that it said, but I feel like the case is not as strong about Back Dam. It doesn't seem that the commission considered the option of keeping Stone Dam, but removing Back Dam.
Your Honor is correct that without removing the Stone Dam, the commission recognized that the benefits removing Back Dam, especially as to increasing river connectivity for recreation and fish passage, were even more limited. But the point is, under longstanding commission policy, the status quo is to leave the dams in place if the licensee doesn't voluntarily agree to removal. And that's especially true whereas here, the dams predate the project by several decades. They were built in the 1920s, and this project wasn't first licensed until 1981. The commission is typically not in the business of ordering licensees to remove dams that they weren't responsible for creating in the first place.
Has the commission ordered licensees who didn't want to remove the dam? Has the commission required them to remove the dam as a condition of granting a surrender license? Before.
Right. I'm only aware of that happening once, and that's cited in our brief as the Edwards case. And in that case, there were very specific circumstances. That case was actually a relicensing proceeding, and the project had to comply with several different comprehensive development plans for the river at issue. I think there were 11 different plans in total. And it was determined that there was no way for the project to continue operating and also comply with all of those different comprehensive development plans, in part because there were several very important species of fish that could not achieve passage by any alternative means. The only way that these fish could survive is through dam removal. And so the commission ordered dam removal, but in doing so, it also emphasized that it wasn't ordering removal, quote, on the basis of an opinion that these several species may or could return one day. The need for dam removal had been demonstrated concretely, and the fish were immediately available to take advantage of removal. Here, there's no comprehensive development plan at issue for the stretch of the river, and the fish passage benefits are too speculative to support removal.
And can you answer my question about the scope of the project? Because the license doesn't include the Back Dam, but the project does. And I was trying to understand how that happened.
Right. You're right, Your Honor, that the license indeed does not include the Back Dam. The commission included it in its analysis given the proximity to other project features, and that's explained at JA 382 of the environmental assessment. But the court is correct that it's technically not included in the license itself.
So is Aclara responsible for the Back Dam?
It does own the Back Dam and operates and maintains it, but it's technically not included within the license that the commission regulates.
I see. So when, I guess, it acquired these assets from GE, it got everything, including the Back Dam, but the license only covers the Stone Dam.
That's correct.
I see.
If the court has no further questions, I'm happy to see the rest of my time.
Thank you. Ms. Nicholson, do you want to take a couple minutes?
I have 3 points on rebuttal, Your Honors. First, FERC's determination that the recreational and fish passage benefits were speculative were not supported by the record. The record, as I stated earlier, contains ample record evidence of the environmental and recreational benefits of removing the dams. But even if this court just focuses on the recreational values in particular, the record does not support FERC's argument that there would be no recreation here because of the industrial setting. FERC has no record support for that argument, and if anything, the record contradicts FERC's determination. This court can look to Aclara's pre-application document, which you can find in the joint appendix on pages 154 and 155, where a clear describes the project boundary as primarily residential, forested, or commercial, and abutted by a forested natural area. So FERC's determination here was contradicted by the record, and they did not grapple with that other evidence. Secondly, the benefits of removing back dam are also not speculative or minimal, as counsel for FERC suggests. At a minimum, FERC was required to grapple with the contrary record evidence put forth by the National Oceanic and Atmospheric Administration in the Joint Appendix at 261, and from the New Hampshire Fish and Game Department on page 350, where both agencies talked about the benefits of just removing back dam. FERC did not grapple with this evidence, and thus its determination was arbitrary and capricious.
That wasn't recreational though, was it?
No, Your Honor, that was with respect to fish and wildlife values. And finally, with regards to FERC's position on licensees not having to remove dams unless they offered, this policy position is inconsistent with the public interest standard that FERC applies and even its decommissioning policy statement. FERC throughout the decommissioning policy statement and even in its brief affirms the idea that FERC has the authority to require dam removal even when the dam owner does not offer to do so. And that's consistent with the public interest standard that they apply. Because as Your Honors may imagine, there might be situations where the dam owner does not want to remove the dams, but it's still in the public interest to do so. So FERC's determination on that specific point was arbitrary and capricious and should not be followed by this court. Thank you.
Case number 23-5275. National Association of Mutual Insurance Companies, Appellant versus United States Department of Housing and Urban Development, and Maria L. Fudge in her official capacity as Secretary of Housing and Urban Development. Mr. Shanmugam for the appellant, Ms. Marcus for the appellees. She didn't say.
Thank you, Judge Henderson, and may it please the court. In inclusive communities, the Supreme Court held that disparate impact claims are cognizable under the Fair Housing Act. But at the same time, the court cautioned that disparate impact liability under the FHA is limited in key respects, in part because of the constitutional concerns about the government's compelling the consideration of race and other protected characteristics. As applied to insurers' rate-making and underwriting decisions, HUD's 2023 rule contravenes the Supreme Court's limitations in two principal respects. First, it would cause race to be used and considered in a pervasive way. And second, it would transgress the requirement that there be a close causal connection between the challenged policy and any alleged disparate impact in light of the limitations that state law imposes on insurers' discretion. The government has blown off those concerns. In 2023, after allowing the 2020 rule to be enjoined, the government simply reinstituted the 2013 rule without any modifications in light of the Supreme Court's intervening decision in inclusive communities. While recognizing some of the problems with the 2023 rule, the district court refused to enjoin it. Because the 2023 rule is inconsistent with the Fair Housing Act, as interpreted by the Supreme Court in inclusive communities, the district court's decision was erroneous and its judgment should be reversed. I'm happy to answer any questions that the court might have on the question of standing, on which the court ordered supplemental briefing. As the court will be aware from our supplemental brief, we rely on two theories. First, the theory that there is self-evident standing here by virtue of the fact that the association's members are directly regulated. And second, we rely on the undisputed evidence that the rule will require the members to incur substantial monetary costs to ensure that their practices comply with the rule's substantive standards.
I understand you have all of these affidavits, but in the face of the Supreme Court decision that says, it warns again and frowns on the collection of data, particularly as it concerns race. And the Federal Register is replete with not just warnings against, but directions that this in no way requires anyone to collect any information, and that the FHA itself has a section that is included in the addendum 3614A that allows the secretary to make rules, including rules for the collection, maintenance, and analysis of appropriate data, and it has not used that. I don't see any requirement, any duty, any likelihood, or anything else of the insurers collecting this data other than this is what they have chosen to do. And so their so-called injury is self-inflicted under Clapper.
Sure. So Judge Henderson, I'm happy to address that. And in some sense, I think that that also relates to the substance of our first claim concerning the pervasive consideration of race. So I will address that in both respects.
All right.
I think the core of our argument here is that the disparate impact rule causes insurers to have to collect and then analyze data regarding protected characteristics. And that by doing so, it inflicts the injury on the companies of having to conduct their practices in a different way and in a way that transgresses the limitations of inclusive communities. And I think that at its core, the government's argument on standing in this respect is very similar to their argument concerning our first merits argument. Their argument is in essence that the rule doesn't really change the existing landscape at all, that it really doesn't require us to do anything beyond what the FHA already requires. Now, we think that that argument is incorrect, and we also think that that's a merits argument that is irrelevant to standing. The reason why Clapper is distinguishable, Judge Henderson, for standing purposes, is that Clapper involved third parties who were claiming that their communications could potentially be subject to the statutory requirement that they were challenging. And that's where the language concerning self-inflicted injury came into the equation. But here, by contrast, our argument is just the ordinary argument of a regulated party. It is that we are being subjected to new and impermissible restrictions on our conduct. Now, the government's...
What is it in the rule? To follow up, what is it in the rule in particular, not your surmise? What is in the rule specifically and in particular that runs inconsistent with inclusive communities?
Sure. So the government's argument here, I think...
No, I want to hear...
Yeah, sure.
I got the government's argument. What is it in the rule, the written rule? As I look at it, and I've looked at it many times and I'm not getting it. What's inconsistent with the written rule and inclusive communities?
Sure. So I think we have two arguments, Judge Edwards. The first is that I think that it is our view that any imposition of disparate impact liability on rate making and underwriting decisions by insurers would cause the pervasive consideration of race. And remember that before...
But that's not before us, like whether insurers are subject to the disparate impact
That's not
under
an issue.
FHA. That's not before us.
Well, just to be clear, the part of our injury here is that the 2023 rule extended unambiguously disparate impact liability to those practices. HUD rejected our efforts to ask for a clear exemption from that. And prior to the 2023 rule, it was not clear that disparate impact liability extended to us at all.
You didn't brief and argue this before Judge Leon. You didn't say we shouldn't be subject to FHA disparate impact liability at all because we're insurers. That's not before us.
Well, to be clear, we made the argument the 2023 rule is violative of the limitations imposed by inclusive communities because it compels a
Yes.
pervasive consideration of race.
Yes.
Now,
But not that FHA disparate impact liability doesn't apply to insurers. You never made that argument. That's not before us.
so we are not making the argument that the FHA does not apply to insurers, nor are we making the argument that disparate impact liability could not apply to practices other than rate making or underwriting decisions. But to get to my second argument, which is the argument that I think focuses on particular features of the 2023 rule, we certainly think that the way that the burden shifting framework that is adopted in the 2023 rule operates puts this on the end of the spectrum where you have particularly pervasive consideration of race. And it may very well be the case that a more limited rule could comply with that limitation from inclusive communities. I think we would likely take the
Can you
position.
explain though why it has to result in pervasive consideration of race?
Sure.
Why does it have to be pervasive?
So I think our view is that when you look at this rule, under which, as we understand it, it is not sufficient simply to say we are applying neutral, actuarially sound considerations in engaging in the rate making and underwriting process. And by virtue of how the burden shifting framework operates, we can be liable even if the alternative practice that a plaintiff comes forward with is not equally effective. We therefore the members have to transform their practices. And this is set out in some detail in the affidavits, but to give you the Cliff Notes version of how that would take place, an insurer would have to review its rate making and underwriting process, and where it determines that there is a disparate impact, it would have to take race or protected characteristics into account. Now, how is that different?
What the rule says?
I think that the rule may not formally require it. And that was the sum total of HUD's response in the rulemaking process was like, look, you can't point to a provision that says you have to consider race. There's no formal requirement. But our principal objection to Judge Leon's reasoning here is that's not what the Supreme Court required. If you look at the relevant language from inclusive communities at 540 and 542, the question is whether or not disparate impact liability causes race to be used and considered in a pervasive way. Of course, if it formally required it, that would—
Can I just ask you, why can't you not do that? And once the claim comes up, then you can look at it and then you can agree or not agree or settle or not settle. But why do you have to completely redo the whole underwriting process? I don't understand that.
Let me just tell you, consistent with, I didn't mean to interrupt, but I just want to add this on, consistent with what Judge Henderson was suggesting in the first place. When I went through this case, my first reaction was, it's not right. There's no right claim here. There's nothing. That's why I asked you, what in the rule compels what you're suggesting? And you started by saying it doesn't, and it doesn't. And there's never been a lawsuit about this. All these many years that this has been this terrible issue that's affecting the industry, no one has brought a suit. There's been no kind of contest about it. And we're having trouble seeing how the possibility of liability even arises. That's why Judge Henderson asked you about standing. I don't see how the case, no matter what, standing or not, to my mind, it is not ripe for our consideration. We do not have, as Supreme Court said in US v. Texas, there's all kinds of possibilities that may result here. If it's ever enforced in any way, let's wait and see how it plays out.
Sure. So I'm happy to address that, Judge Edwards, and in the course of that to address Judge Pan's initial question as well. So first, this is obviously a pre-enforcement facial challenge. We acknowledge that our burden is therefore to show that the rule is invalid in all of its applications. I don't understand the government to be framing its any objection here in ripeness terms.
I don't need the government's.
Yes, but I understand that it's jurisdictional. So therefore, I will address it directly. I think that the problem with understanding it in those terms is that it effectively leaves no room for a facial challenge to operate with regard to a challenge to a disparate impact rule.
But the problem is, I have to stop you here. This is why I asked you the first question. Facial challenge means I can look at the rule and see your problem. None of the three of us looking at the rule can see your issue. It's not It's not there when you read the rule and you look at inclusive communities. You can't say, well, wait, what is in the rule that is taking issue with inclusive communities or trying to do something different? It's not there. And what you're really saying is this might play out badly for us if we get some bad administrators. They might bring an enforcement action that's not to our liking, and we want to preempt that way in advance. That's exactly why it's not right.
So I would say two things in response to that, Judge Edwards. The first is that I think that with respect, it slightly misapprehends inclusive communities, because I do think that inclusive communities said that the limitation that the court was articulating, which is I think a limitation as a statutory interpretive matter on the availability of disparate impact liability, is a limitation that that liability cannot cause race to be used and considered in a pervasive way, not that there has to be some formal requirement of that. Frankly, if there was a formal requirement that race be considered, it would probably be unconstitutional. I think for purposes of the court's analysis, what the court was saying is you just have to look at the operation of the disparate impact liability framework. And that's why we came forward with affidavits explaining how disruptive this would be for the practices of insurance companies. And I don't think with respect that it's enough to say, well, look, there haven't been any of these actions. If there are these actions, you can deal with them then. Obviously, insurance companies, like other regulated parties, are going to immediately seek to conform their practices with the requirements here. Now, one of the difficulties with that, Judge Edwards, and I want to bring in our second claim here, is precisely because of the inconsistencies with state law. Even if you don't agree with me that we have made a showing here that as a facial matter, there's going to be a problem because of the pervasive consideration of race, because of the way that the rate making and underwriting process works, I think you do have to look at the requirements of state law for purposes of considering the other important limitation that the court imposed, which is the robust causality requirement. I think that there is agreement between ourselves and the government, and you'll hear from Ms. Marcus in a minute, that if you had a situation in which the states outright banned the consideration of race and other protected characteristics, that you would have a problem under the robust causality requirement.
But in your facial challenge, you have to show that every state in every instance breaks
Right.
that causality. And
Yes, and I think that the disagreement between us and the government is about that. It is about the operation of state law. And we in our brief walk through all 50 states and the District of Columbia, and we point out that many states affirmatively, explicitly prohibit the consideration of race and other protected characteristics. Other states do so by prohibiting unfairly discriminatory rates and the like. And further, the states have affirmative provisions that set out the factors that insurers can consider in the rate making and underwriting process. And again, remember, going back to what the Supreme Court said in inclusive communities, that all that we have to show is that another source of law, quote, substantially limits the defendant's discretion for purposes of breaking the causal connection. So even if
a viable case comes up, that when something becomes ripe, that would be the argument you'd make.
well, I think
Wait your day.
what was a little bit confusing about Judge Leon's reasoning is that Judge Leon seemed to suggest that even if state law could always sever the causal connection, that we would have to wait another day. We would have to wait to raise state law as a defense. And again, I think that really, Judge Edwards, leaves no room for a facial challenge to operate here. And I acknowledge that it is our burden under Hodge versus Tolkien and all of the other familiar cases to show inconsistency in every application with regard to both of these arguments. But again, I think that we have successfully done so. And again, we point to a compliance cost.
Really address this pervasiveness question and why it has to be a pervasive consideration of race. And I'm wondering if you might be able to put this in a concrete example. Like, so for example, there's been a claim that's been referenced in the materials about a claim that insurers are not providing insurance to properties that accept Section 8 housing vouchers. So can you explain like how your theory of pervasive consideration of race fits into a situation like that?
Sure. So that I think is the fact pattern basically of inclusive communities itself. I think it involved, landlords who did not accept Section 8 vouchers.
No, that was like where they're going to locate something. I thought that's what inclusive communities was about. Or am I mixing that up with another case?
Yeah, I'm not sure, but I'm sort of happy to address this in a specific context. So, let's say that insurers take some factor into account in the rate making and underwriting process. For instance, I'm slightly going to.
Acceptance of Section 8 vouchers. That's the example.
Yeah. So whatever factor it is, I think insurers would then have to assess whether or not that practice has a disparate impact based on race or other protected characteristics, because that is, after all, the substantive legal standard that is being challenged.
Right, but it's not a pervasive look in this particular instance, is it? Because I thought you were saying that it's going to require the companies to redo the entire way they assess risks.
Well, I think what would happen, Judge Pan, is that for that factor or any other factor, say it is whether the house is in a low-lying area, whether the house has a sloping roof or a flat roof, with regard to each of those actuarially sound factors, an insurer would have to consider whether that has a disparate impact on multiple axes, not only with regard to race, but with regard to all of the other stated protected characteristics. If it does, the insurer would presumably have to take those factors into account and essentially redo the rate making, the classification, and the grouping process in order to come up with a process that was compliant with the legal standard.
So how would it work then in my example? Like, why couldn't it be that once there's a challenge to this policy, then they could look at it and see if there's something else they could do different? Just charge a higher premium, for example, for a property or whatever. But why would it have to, I guess, happen at the front end and be pervasive as opposed to just case by case?
Well, I think that, but I think the alternative is to basically say, you should just violate the law and wait to be sued. And then when you are sued, you can change your practices.
You're assuming
then.
so many things that are not here. That's what's so frustrating. And I don't mean to look frustrated, but I am frustrated. When you say facial challenge, like, Judge, please don't take that opportunity away from us. A facial challenge means I look at the document facially, and I look at 1, 4, and 6, and I say, those requirements are inconsistent with law. The things that you are worrying about aren't stated in the document that you want to challenge. That's why my reaction is, this is not ripe. You can't point to anything to support a facial challenge because there's nothing in the regulations that is directly inconsistent with inclusive communities. You might get a bad judge. You might get a bad appellate court later on that goes the wrong way, and then you have to fight it out. But facially, it's not there. That's why US v. Texas is precisely the case. You need to look at it again. The Supreme Court says, yes, you can come up with all kinds of hypotheticals that seem worrisome to you, but we're not going to guess now. Let's see if you run into a problem later.
I mean, Judge Edwards, I would respectfully disagree. But even if you take that view, and leaving aside for the moment.
That's not my view. That's the Supreme Court.
Well, even if that is the Supreme Court's view, let me explain why I think we would still satisfy that approach. Now, I want to put aside for the moment our view that it will not surprise you to hear that our client's view is that any application of disparate impact liability to rate making and underwriting procedures is going to cause a problem for the reasons that Judge Pan and I were discussing. Let's put that aside for a moment. Let's look at the operation.
In this case, whether a disparate impact can cover your clients? Is that an issue in this case?
Well, I mean, I make that.
Oh, really? Wait, because you didn't really answer Judge Pan initially. That's not an issue in this case.
Well, so we are challenging the 2023 rule, and one of the effects.
No, you're challenging your view of the rule. And one of the things that my colleague asked you is, are you challenging the inclusion of your clients under the impact? And you said, no. That's right, you're not. So this is why this makes no sense what we're doing here.
So just to be clear, we have consistently taken the position our view is that the imposition of disparate impact liability on these processes is improper. We obviously raised that issue in our objection. And I do think that one way in which the 2023 rule clarified the law was to reject our argument for an exemption and to extend disparate impact liability unambiguously even to rate making and underwriting processes. I recognize that the two claims that we are making here are, first, that the 2023 rule requires a pervasive consideration of race, and second, that it fails the robust causality requirement. And I want Judge Edwards to go directly to your question about, with regard to the pervasive consideration of race, what is so problematic about this rule? And I would juxtapose this rule to the 2020 rule, precisely because this rule pushes the boat out about as far as it can with regard to the operation of burden shifting. And I would point to a couple of features that I think are particularly problematic. And so if you're looking at this in terms of what is it about the rule in particular that causes the pervasive consideration of race, I would point to two features. The first is, and if you look at the second step of the burden shifting framework, it says that the defendant has to show that a challenge practice is necessary to achieve one or more substantial, legitimate, non-discriminatory interests. And one might very well wonder exactly what that means, but I think that what it means, and you can ask Ms. Marcus this question when she gets up here, is that it isn't enough just to say these are actuarially sound, protected, characteristic, neutral justifications, that what we're doing is what we have always done, which is to rely on actuarially sound factors in the rate making and underwriting process. Now, second, and I think that this may be perhaps the most pernicious part of this, the plaintiff can prevail at the third step, and this is also incorporated in the substantive standard in the previous subsection, that, quote, the interest supporting the challenge practice could be served by another practice that has a less discriminatory effect. So it is not that the plaintiffs have to show, as was true under the 2020 rule, that the alternative policy is equally effective. It can be that we can be held liable even if the alternative is less effective. That, in other words, if it doesn't serve the actuarial considerations that underlie the rate-making process, simply because the alternative has less of a disparate impact.
And so if you won this case and you were allowed to write the opinion, what would your remedy be? What would we say? Well, you are now awarded what? You won your facial challenge, and here's what you're getting. What?
You should vacate the rule insofar as it applies to insurers' rate making and underwriting practices. And I think that would be a remedy that would address the concern we're raising. We're not saying that you should vacate the rule as it applies to all insurer practices. You can have other practices with regard to certain pricing discounts or redlining and the like. I think someone could even bring a challenge if they wanted to a practice like bundling. So in other words, we're not asking for an exemption for insurers from all practices. And that is, I think, the pretty standard APA remedy for a facial challenge like this one. Now, of course, we're operating against the backdrop of the fact that there's a very real likelihood that the 2023 rule will be modified or even superseded once again when the new administration comes in January. And all I can say about that is that this litigation illustrates the fact that there has been a ping pong on this issue across administrations. I certainly think that a rule like the 2020 rule would reduce the consideration of race, because I think that as a practical matter, this is something of a spectrum. The more onerous the disparate impact liability standard is, the more, as a practical matter, that insurers are going to have to take race into account.
In your view, is there anything that we should do to account for the real fact that you have raised, that there is going to be a change in administrations? The prior Trump administration adopted a very different rule. Should we perhaps ask the government to state its position with respect to this case on February 15th or something like that?
I think that would be a very practically reasonable thing for the court to do in light of the fact that the new administration will be coming into office 2 months from today. And I think that the court could promptly issue an order asking the government to state its intentions at that point. recognizing the reality that whatever this court ends up doing, there is a very real prospect of that change. And I do think that if the court does that, it should set a relatively prompt deadline for the government to state its views as to how it wants to proceed.
And if we dismissed for want of ripeness, that would have the same result, and it would be legally cognizable. It would be something I understand, and we do it all the time, and your position would not be hurt because that is a dismissal without prejudice. We're saying it's not a case that's properly before us. And then whatever it is the government does or doesn't do, they'll do or don't do, and then you may be where you want to be eventually.
But
I want to do it in a way that I understand that we are required to do as judges on this court. This case is not right.
Judge Edwards, I think what I would say is that I do think that it is telling that the government is not making that argument before this court.
It's not the first time that that's happened, and the government has lost along with parties on your side of the table.
But I think I would also say that I think that we have done precisely what should be done in a facial challenge when the substantive standard is a standard like the one that the court articulated in inclusive communities. Remember the concern that motivated those last few pages of Justice Kennedy's opinion in inclusive communities. It was the long-stated concern that too expansive of a disparate impact standard could raise constitutional concerns. And that is why the court recognized these guardrails on disparate impact liability. And those guardrails, Judge Edwards, require you to look at the practical operation of the provisions. And it was for that reason that we came forward, as Judge Henderson indicated, with the 15 declarations that explain in unrebutted terms the operation of the rate-making and underwriting process and the disruptive effects of this rule. I don't think that there was anything more that we could do, and that's why—
Those were all tied to this collection of data, which nobody has required, but has frowned on.
Well, I think what I would say, Judge Henderson, about that is two things. First, that to the extent that the government sets great store by the fact that there have been no enforcement actions by the government and relatively few private actions in this intervening period, I think that is precisely because of this lingering uncertainty about the law that we've had over the last decade, where there have been challenges both here and in the district court in Chicago on precisely these grounds and others. But I think that the second thing that I would say about this is that I think that as a practical matter, this is the reason why we aren't able to come forward and say, we are collecting this data today and analyzing this data today is precisely because the members are in a complete bind here. The members are subject to these state law prohibitions. If you look, for instance, at the Declaration of Thames, which is at pages 72 to 75 of the Joint Appendix, that company, Harford, operates in Maryland, where there is a specific prohibition on the collection of data of this variety. And so in some sense, the problem that the insurers have right now is the complete uncertainty about the law, which is where our second argument comes in. We believe that there is a conflict in every application between federal law and state law. And Judge Edwards, you can look at the terms of the laws to make that determination. And all that the government has to offer is the say-so of certain state attorneys general that certain states permit disparate impact liability without any authorities for the proposition that disparate impact liability has been applied to homeowners insurers in this context. So even if you take the most stringent view that you're only going to look at the four corners of the United States Code and state codes, we would prevail on our second claim under that approach. Unless the court has any further questions, I'll reserve the balance of my time for rebuttal. Thank you.
Thank you. Ms. Marcus?
Thank you. Good morning. I'm Stephanie Marcus from the Department of Justice, and I represent Appellee's HUD and the Acting Secretary of HUD. I'm going to start with standing and ripeness. We believe that this case should be dismissed for lack of jurisdiction because the plaintiffs do not have standing and because it is not ripe. As Judge Henderson, your questions reflect, the plaintiff here has not shown that any of its members have an actual or imminent injury, in fact, at all, much less one that is traceable to the 2023 rule. The 2023 rule reaffirmed the burden shifting approach that was first adopted in 2013. And in 11 years, the members have not come forward with anything. They only have speculation that they will do this in the future. But as your honors had pointed out, in the rule itself, HUD expressly disavowed a requirement that anyone has to collect data or use data.
But aside from the data collection theory,
Yes.
There's a theory that they are a regulated party.
Yeah.
And this rule subjects them to more liability than an alternative version of the rule, like the 2020 rule would. And it's also more stringent than some of the other burden shifting tests that some of the circuits had previously adopted. So why isn't that enough?
As this court has made clear in a number of the cases we cited in our supplemental brief, including the American Chemistry Council and the National Association of Home Builders cases against EPA and the U.S. Corps of Army Engineers, just being a regulated party that's the object of regulation is not enough. There's still, that doesn't eliminate
But
the
I
article.
also said the increase in liability
Oh.
to them is a combination of the two, that this would
But
be the
this-
argument they would make. They are subjected to more liability under this version of the rule than, for example, the 2020 version of the rule. So there are different ways of
But-
imposing a standard that implements the FHA's disparate impact framework.
I think that the rule doesn't increase the substantive liability under the Fair Housing Act. It doesn't expand liability in any sense from the statute itself. HUD is not purporting
But
to
it's more
decide.
burdensome. Let's put it this way. It's more
But they
burdensome
haven't-
for them to prove liability or not under this framework than the alternative frameworks that are available.
For them to, I mean, the plaintiff has to prove the liability. They
to
just need to,
defend.
to defend. But they haven't shown that because they haven't shown again, they actually pointed out in their reply brief that there's never been government enforcement in court against a homeowner insurer. And with the lack of any kind of imminent government enforcement, here it's just a sort of way that HUD administratively will deal with the claims in the administrative process. An insurer always has the option to go to federal court. If there's a complaint, administrative complaint filed.
You're saying they can't make a facial challenge. There's no way in which they can do so. They can only make an as-applied challenge?
If they're in the future, a party could show some sort of injury. I'm just saying in this case, they cannot make a facial challenge
I'm
because
saying
they haven't shown
You're
standing.
saying that insurers
Insurers,
subject to this rule cannot make a facial challenge. They will never be able to show injury by this.
I'm sorry, Your Honor, I don't think I need to show that they would never. I'm just saying on the record of this case, they haven't shown an injury. I don't know if an insurer in the future could show an injury, but there's nothing
But
on
if
this
they have to
record.
spend any money to
No,
sort of comply with this rule by saying, well, now we're going to have to look at this a little bit differently.
then they
I know that there's an argument that, well, it's coextensive with the FHA, but given that there are different standards that are also permissible apparently under the FHA, this particular one is going to require them to maybe
But they can
be more
argue.
careful
The problem
in
with
documenting their work than others.
no, I think the problem is that they can come into court and argue what they think the FHA burden shifting framework should be, and that's
As-applied challenge is what you're saying. As
Yes.
opposed to again,
And-
you're saying they cannot do it.
and
in a
they have
facial
not-
way.
and because they haven't shown that this will cause them any kind of cost. It's that they won't conduct their business any differently. And it's also not right because these, right now,
Well, there are all these affidavits that say they're going to conduct their business differently.
but they they just don't even give a time when they're going to do that. And the rule has been in effect for 11 years. I don't see how that harm can be imminent. They didn't update the affidavits. And they haven't shown today how it's different now.
Taking the best I can figure out from their argument, they're suggesting that because of the change in rules, actuarial practices are now more directly implicated in ways that they were not before. That's the best I can get from what they're saying. And that piece of it, they're saying, the actuarial practices would now be subject to potential liability under their view of the rule. And this is different from what existed before, and it imposes a burden on them now to get ready for that possibility.
Your Honor, they can't show that it's different from what it was before because the 2020 rule never went into effect. It was actually enjoined before it became effective by a district court in Massachusetts. So the 2013 rule has remained in effect. And so they haven't shown that there's been a change in the standards that they're subject to, or that there's been an increase in liability. But in any event, they haven't shown how a rule that doesn't have a substantive requirement. I think it's easy to see the problem with their standing and ripeness when you look at the regulated party cases that the district court relied on in its first opinion in finding standing and how different they are. If you have, for example, a petrochemical manufacturer who is subjected to new pollution standards, that's a substantive requirement that manufacturer is and so by the rule itself, it affects the regulated party. Same for someone who operates a water system.
So why isn't the change not from the 2020 rule to the 2023 rule, but just the 2013 and the 2023 standard versus what happened before? And because there is this argument that this is coextensive with the FHA, but I don't think it necessarily is because there are different versions of the rule that could comply with the FHA. And so then it's just a question of they're insurers, right? So they're risk assessors. So they're going to have to do something to comply with litigation risk in light of the standard that they're going to have to meet if they're sued. And they're going to have to, I don't know that it has to be a pervasive consideration of race, but they're going to probably make some adjustments to the way they to set their policies based on this rule. And why isn't that enough? Because they're a regulated party that's subjected to the standard. Because
to the extent they would do that, that would be because of the Fair Housing Act itself and because of inclusive communities.
No, but not because this is different. There are different ways of doing this that are consistent with both inclusive communities and the FHA. But I mean, it's subject to debate, but there was the 2020 rule. You could have a rule because inclusive communities has that language about it has to be something that's arbitrary and unnecessary. You could have a rule that says plaintiffs should show at step one it's arbitrary and unnecessary. There are lots of ways to comply with the FHA and inclusive communities that are not this standard. But this is the one that the agency adopted and they're subject to it. So why don't they have standing?
They're subject to it, but they will have a chance in any given case to argue de novo in court. Like HUD can't. They can't challenge it as a facial challenge. It has to be as applied in your view. But I don't see why that's the case if they have standing to challenge it as a facial challenge based on what I just said. Okay, and they don't, and we think they don't have standing because they need to show that some difference in a burden shifting framework would cause them to act differently. And this burden shift. We have all these affidavits that say that they will. It might not be pervasive, but they're risk managers and they're going to do stuff to make sure that they're in compliance. But then when are they going to do it? I mean, this has been the same. HUD was just reaffirming a standard that it first adopted in 2013. And even if theoretically there could be some different, and there is, I mean, different circuits have slightly different frameworks. And that's still, they haven't come forward with an affidavit saying that they're doing things differently. One example, it's the Second Circuit actually held that the Supreme Court implicitly adopted the HUD burden shifting framework in inclusive communities. Have they come forward with a member within the Second Circuit that has done something differently since then? Or has incurred costs or started pervasively considering race? No. And the rule doesn't require it. And they just simply don't have standing. And it's not right for a lot of the same reasons why their facial challenge fails. Because a lot of the objections they're bringing up, they can argue in an individual case, but it's their burden to show that every case they would be required to pervasively consider race. And Judge Bates, I think Your Honor was referring to Judge Bates's decision in 2017 in the Travelers case with the Section 8 housing. He denied a motion to dismiss on the insurer's behalf. And since that case, they haven't come forward and said, we're doing something differently. Also, an important point in that case, he also refused to dismiss the DC law claim. And that's an example where it was allowed to go forward. The case ultimately settled, but all of these, dire predictions of the insurance companies have not come to pass. And we have the Prudential case was in 2002. We have the Vians case in Connecticut that involved a Connecticut claim and a federal claim under the FHA.
Can you address the impending change of administrations and what's the most efficient way for us as a court to deal with this?
Well, I think, Your Honor, because our position is that the court does not have standing and the case isn't right, that isn't, I think that isn't affected, that position. And I think it's up to the court. I mean, of course, we are defending the rule and fully defending it. And that is, clearly our position now. And the court knows that this administration is still here through, January 2025.
I just think in this particular case, we actually have a Trump era rule that is different from this one, which is a strong indication that there's going to be a change of policy in this case, potentially. And for us to expend the resources to decide this case, whether even on the basis of standing, et cetera, it's a lot of resources.
Do you think the rule affects actuarial practices, says anything about it?
No, I don't. Let me modify that. It makes clear that it is not in any way like trying to prohibit risk-based or actuarial practices. It in fact says that HUD recognizes that those are legitimate non-discriminatory practices. And it's not trying to, do away with those kind of practices, but it certainly does not prohibit them in any way or restrict them. If the court has no further questions, we would ask that it remand for district court to dismiss for lack of jurisdiction or affirm the district court's decision. Thanks.
Does he have any time left? Why don't you take 2 minutes?
Great. Thank you, Judge Henderson. Just very briefly on the justiciability arguments. I think a helpful way to think about this is to characterize the 2023 rule as essentially creating a duty not to engage in practices that create a disparate impact where other less discriminatory alternatives are available, even if those alternatives are not equally effective. And our affidavits showed that the only way to comply with that duty is to modify our practices. And that is why there is self-evident standing.
Actuarial practices?
Yes, that is.
I don't think that's what the rule says. That's exactly my concern. You are self-servingly pressing that point as if it's self-evident. When I looked at it initially and listened to this argument for over an hour, that is not what the rule says to me.
Well,
it's not even when you shift up and down in the bird, because it would not be, in my view, a discriminatory practice to have the usual business actuarial practices in play for an insurance company to make determinations. I think your argument is bogus, to be very honest with you. I get your concern as business people, and I understand what you're worrying about, But this case just doesn't present anything because the rule doesn't say that those actuarial practices are in jeopardy. It does not say that.
And I think that ultimately that is where I have to disagree respectfully with you, Judge Edwards. I don't think that inclusive communities itself requires a formal requirement. It does not require the rule or the underlying statute somehow affirmatively to operate on actuarial practices or to require the consideration of race. And I do think that the colloquy between Judge Pan and my friend, Ms. Marcus, illustrated the problem here. If you take that view to its logical conclusion, I don't think that there is any room for a facial challenge to operate in this context. Any argument would have to be as applied. And that is why I think that this is the paradigmatic context in which we are a directly regulated
That's a bad
party.
thing, you think? We do that all the time. There are
Well,
lots of cases where you can't get a facial challenge.
Look,
I'm not, why is that?
I-
Why is that problematic?
I think it would be true with regard to any challenge of this variety to a disparate impact rule that transgresses the bounds imposed by the Supreme
See,
Court.
I'm not
And
getting, we're just not seeing, we're not on the same page in our understanding of ripeness. And if you read, I urge you to read US v. Texas, Supreme Court said, we're not going to guess about the possibilities. We'll see how it plays out. It would be irresponsible for a court to do that. And that's exactly what I'm saying, especially for someone like me who can't comprehend your argument that actuarial practices will fail, either under the law, the Supreme Court statement, or the rule.
well, Judge Edwards, I
And
think
that seems to be your only concern.
I think
Well,
we're
why would
talking
I
about-
take this case now.
I think we're talking about two slightly different things here. And while I think Ms. Marcus admirably tried to embrace your suggestion that there's a ripeness problem here, I start from the proposition that with regard to standing, we are directly regulated parties here. And with regard to ripeness, I think that the problem here, and I don't want to belabor this, if you disagree with me, we'll have to agree to disagree. But my view on ripeness is that in this context, we're bringing a facial challenge. It is entirely permissible, and I'd go all the way back to Abbott Labs on this score, to come forward with evidence as to how the rule is going to affect our practices. We do not have to show that that has already taken place.
Right.
I want to say just a word about the substance of the claims here, and I will be very brief, mindful of the time. I want to say a word about the Travelers case, which I think is the case that you were perhaps thinking of, Judge Pan, when you asked your question. We recognize that there may be certain practices by insurers that fall outside the category of rate making and underwriting practices. I gave the example of redlining. And so, for instance, if you had an insurer who, after the rate making and underwriting process, said, we refuse to provide policies to people who have Section 8 vouchers, or we refuse to underwrite policies in a particular neighborhood, those challenges could still go forward. Our view is, with regard to the pervasive consideration of race, that the features of the 2023 rule that we have been discussing are what takes this to the end of the spectrum where the consideration of race is particularly pervasive. The Supreme Court and inclusive communities seem to think that there were certain types of disparate impact liability that would be okay, and certain types that would transgress the limit by going too far in mandating the consideration of race. And we think that the 2023 rule is on that end of the spectrum. And again, I certainly think that it would be appropriate for this court to wait the short period of time to see what the new administration wants to do before ruling on this case. We would ask that the judgment of the district court be reversed. Thank you.